All right, welcome for this week's Rising Tide Foundation lecture with a Canadian Thanksgiving special. We have here today Adam Sedia once more, who is typically brought out. I've been bringing out Adam as a sort of intellectual weapon to discuss matters of poetry, history. Today, it's going to be a little bit of both of those elements, but tied to something that Adam has been working on as his own career and passion for a number of years as a lawyer, who has been thinking deeply about the question of law as far as it relates to the idea of law and how to best affect and create laws that are in alignment with God's law, natural law that is already there in the universe, and what types of laws or false ideas of laws are out of whack with those already existent rules of the universe. I got somebody just in the waiting room. Okay. So today, Adam has graciously volunteered his time and energy and mind to the topic that is close and near and dear to all of our hearts. I think if you're here, you already care about this, on the topic of freedom, unity, wisdom, America's justice system as constitutional order envisioned in Plato's laws. This will not happen in the course of simply one sitting. It will be divided into two presentations. We don't know when part two is going to happen, whether next week or whether the week after that. We'll talk about that. But definitely there is a tendency that I have noticed of people who try to oversimplify the idea of law, to the point that they lose a sense of truth. And I know when I was I took a criminal law class when I was in university, and just as an elective, and I was horrified that the privy counselor, who was also the professor, had a room, an auditorium full of at least 100 aspiring lawyers around him, all, green, ready to learn what is this thing called law as they prepare to go out into the real world. And his first lesson was, there is no such thing as truth in law. All that matters is, can you win in your argument? And doesn't matter, your job is not, if you're defending somebody, it doesn't matter if they are guilty or not, your job is to win the case. And that was his first lesson, upon which every other lesson was built. Terrible, poisonous foundations, but it's really a big deal when this becomes, again, he's a privy counselor. So that gave me at least an early sense of why our society is messed up and why we allowed good things to turn into rotten things, and how to maybe potentially restore some governing core principles once more. And so, Adam, I'm not going to say anything more. I'll let you just take the show. And as usual, once you're done, if people have questions, please put your name in the description or in the chat box, and I'll call upon you accordingly. Adam, it's all yours.
Well, thank you, Matt, for that lovely introduction, as always. Let me just share my screen here.
I got to give you screen sharing. Yeah, sorry. Hold on, let me do that. Make co-host Adam. Yes. Okay, you now can do that.
Okay, great. And let me put this on presentation mode. All right, how do we look?
Great.
All right, so I have this presentation structured in a way backwards, rather than starting from the big ideas and working it into practice. What I'm going to do is track the development of law, which was very much unorganized, unplanned, and haphazard from medieval England to colonial America to this thing called the Constitution, and trace its developments pretty much up to the present day. And then we're going to switch gears and then examine Plato's laws, which I think is his most interesting, well, maybe second most interesting after the Phaedo. And I think his most underappreciated dialogue, to discuss how these principles apply in the US Constitution and constitutional law more generally. And the title, Freedom, Unity, and Wisdom, is drawn from what Plato in his laws advocates as the governing principles of a constitution. So we're going to get started as far from a organized, rational constitution as possible in medieval England. So what we call as the common law is, for those of you who might live in Europe or even Quebec, you're used to a civil law system and in the United States, Louisiana has this system where everything is codified. All the rules of law are written out, legislated, and all your case is just applying those quick principles of law. What common law is, it derives from Germanic customary law from the days before the Angles and the Saxons and the Jutes in England had written language, and it was just application of custom to situations that reflected precedent. And when William of Normandy conquered England in 1066, he left the system largely in place, but gave it structure and order. He and his successors gave it structure and order and imposed very much a French style system on the pre-existing English Germanic traditions. And in fact, most of the English vocabulary relating to law and law-related things comes from Norman French. For example, we have law is related to French loi, court from cour, judge from juge, jury from juré or sworn. Those all come from French rather than the Germanic roots, which are completely different. If you Gericht, Gerichtshof, if you know any German, they sound nothing like the English analogs. So that very much shows where the power structure was and how the courts were set up. The real beginning of English common law courts starts with Henry II, who we have here. He was the Duke of Anjou in France before he inherited the throne from his cousin Stephen, and he began really the process of centralizing royal authority that William had begun, 3/4 of a century earlier. So what Henry did is set up 3 royal courts, theoretically all at Westminster. You still had the local county courts, which were run by justices of the peace, who were appointed by the king, but they were just property owners. They didn't have to be trained in the law. So you got quick justice, but it wasn't always right. The royal courts required their judges to be trained in the law. So you had to go to London to plead your case, and it took time and there was backlog, but you would have competent, learned, and literate judges deciding your case. And there were 3 of those courts, 3 royal, there was a 4th court we'll get to in a second. They were the King's Bench, which theoretically was adjudicating all parties to which the crown itself was a party, other than financial matters. This was mostly criminal matters that involved the king himself, such as counterfeiting, treason, highway robbery, things like that. The attorney general, the solicitor general, they weren't prosecuting public crimes. They were prosecuting crimes against the crown as a private individual, essentially running the government. There was the Exchequer of Pleas, which was a collection court for debts owed the crown. And then there was the Court of Common Pleas, which governed suits between private persons, which was everybody else. And as you can, we have pictures of the King's Bench here. As you can see, the Middle Ages depiction and the mid-19th century depiction, there's not a whole lot of difference in that. You have the 5 judges sitting in their red robes next to each other, and the clerks in front of them with their papers, and the lawyers all lined up at the bar, which you can see an actual bar with prisoners shackled at their ankles in the middle depiction. That's where the word being admitted to the bar comes from. If you were an attorney, you crossed that bar and were able to address the court. Each court had 4 to 5 judges, they were appointed at the king's pleasure. Usually they served about, and they were required to be trained in the law, and then there would issue around the country and hold trials 4 times a year at sittings called the assizes. And that's where the term riding comes from in Canada and Britain, or the term circuit court in the United States, when the judges would actually ride the circuit to hear cases with juries. The criminal charges were brought by a bill, and the bill was brought by a grand jury, which was 14 to 23 property owners whose job was theoretically to sit while the judge was away and determine whether charges could be brought in the intervening time before the judge rode circuit there. And it took a concurrence of 12 grand jurors to issue a true bill, which was an indictment, and that would authorize the sheriff to arrest the defendant and hold him for trial when the judge showed up. If the jury did not indict, they would issue a bill called ignoramus, which means we do not know, and that's where the term ignoramus comes from. You'll get a lot of this, etymologies from this history of law here. Civil cases were a totally different animal. Civil jurisdiction was obtained by issuance of a writ, which was a command to appear in court and answer the charges, the civil charges against you. And like anyone could petition a writ to the royal court. What it defined a cause of action. It was essentially, I've heard the term called off the shelf, or I would say prefabricated justice, where it was designed to make things easy for the judges, where there was a clear set of elements to the action and a clear set of relief. So if you couldn't come in with a generalized or even a particularized complaint unless your allegations met the elements required to issue the writ. And the writs were titled by their different actions. And because defining a new cause of action was technically legislation, the courts considered themselves not at liberty to recognize a new cause of action like frequently they do today. That it was the prerogative of the king through royal decree and later parliament through statute to define an action. And Edward I fixed the writs in the late 13th century. So for the next 600 years, English pleading was frozen into the form of writs. And regardless of your claim, you had to pigeonhole it into one of the existing writs, or your complaint would be dismissed. And this led to what we call common law pleading. There were no set of rules to follow other than your petition had to meet the requirements of the writ. And this led to highly formalized and elaborate pleading. And when I say pleading, I just mean the allegations and responses to the allegations. Under common law pleading, you had theoretically infinite back and forth between the plaintiff and the defendant responding and replying. You had pleadings, you had the declaration, the plea, the reply, the surreply, the rejoinder, the surrejoinder, on and on and on, theoretically forever, until the issues were narrowed. And the judges would issue their decisions on all of these. And once you came to a triable issue, then it would be referred to a jury trial at the assizes. The pleading also depended highly on keywords, and over the years, it became dependent on a high number of legal fictions. My two favorite and perhaps the most notorious examples in the use of legal fictions are number one is the dispute over property ownership. If you were disputing ownership of a parcel of property, the proper petition was a writ of right, which was the oldest an original writ, and it was so ancient that you were entitled to, either party on demand was entitled to trial by combat. Now, in the Middle Ages, you didn't have to fight yourself. You could hire a champion to fight for you. Well, the better champions cost more money, so it meant the party who was richer usually won. So what a lawyer figured out in the mid-13th century or thereabouts is, rather than petitioning outright for a writ of right, they would make the allegations as a petition for a writ of novel disseisin. And what he would do is allege that the plaintiff rented to a certain John Doe, who then was kicked off the property by a certain Richard Roe, who then paid his rents to the defendant. Now, John Doe and Richard Roe were totally fictitious entities, but it didn't matter what the evidence ultimately showed. All that mattered was the allegations of the pleadings. So by requesting the writ of novel disseisin, you were no longer entitled to trial by combat, and the case would proceed to a jury trial like normally. And this became the standard practice for the next 600 years or so. And that's also where the terms John Doe and Richard Roe originate when we refer to anonymous or unknown individuals. Interestingly, in the early 19th century, there were a couple attempts to revive the right of trial by combat, where someone specifically petitioned for a writ of right in the 1820s, I think. And the judges by then said the practice had been fallen by the wayside for hundreds of years, that they would consider it obsolete, and they denied the petition. So there were people who at least still wanted to fight over their property. The other interesting one is what's called the Writ of Quamanus, and this had to do with the court you were in. As I mentioned, the Court of Common Pleas was the everyman's court, and of course it had the largest caseload. So the court with the smallest caseload was the Exchequer Court, because it only dealt with debts owed the crown. So what a party who had a grievance against another private individual for money owed, it would ordinarily be a writ of debt or a writ of detinue, which would fall in the jurisdiction of the common pleas. But what they would do instead was plead the writ of Quamanus, where they would allege that they, the plaintiff, owed money to the crown, but they couldn't pay it because the defendant owed them money. And what that allowed the plaintiff to do was have sort of a pass-through collection. But it didn't matter, again, what the actual, and theoretically everyone did owe money to the crown in the form of a tax or of some form or another. But again, what mattered was the allegation of the pleading, and the legal fiction brought it within the jurisdiction of the Court of Exchequer. And pretty soon everyone started going there. To complicate this matter further, the courts were not funded through taxpayer or government funds. They raised all their money to pay salaries, operational expenses from filing fees. So the courts were really in competition with each other over who could get more cases in front of them. And this went back and forth over the centuries. And by the 16th century, the three royal courts had reached a gentleman's agreement, so to speak, where the King's Bench would have jurisdiction over tort, that's personal injury cases and criminal matters. The Exchequer Court would have jurisdiction over all contract and commercial disputes. And then the common pleas would hear all property disputes, and the courts sort of became specialized that way. And they would remain that way until their consolidation in the 1880 Reform Bill. And as you can see here, there's a fairly complicated scheme of the court organization, and I'll get to the Chancery and the Lords in a second. The King's Bench, of the three royal courts, the King's Bench was considered the highest court. And originally it was where the king sat with the judges, and the court traveled with the king. That gradually fell by the wayside, and the court sat permanently at Westminster without the king present. but it did have what was called, it had sole jurisdiction to issue the 6 what were called prerogative writs. And in some jurisdictions where these haven't been superseded by statute or by rule, they're still called the extraordinary writs. There are 6 of them. And these I'm going through them because these will come up. They're the first 2 are mandamus and prohibimus. And again, these are all in Latin because they're named after the incipit, which is the first word of the writ that would issue. Mandamus means we command, and prohibimus means we prohibit. It's an order to a royal official, including other courts, to do something they're obligated to do or not to do something they're forbidden from doing. The third one is quo warranto, or which means by what authority. It's a situation where it's not clear whether the action was authorized. It's a command to another court or a royal official to show the authority on which they're acting. Number 4 is habeas corpus. You have the body is what it means. This is also called the great writ. It's a command to an official who has custody of a person to show that their custody is justified. For example, if someone's being held and there was never an indictment, a proper indictment by a grand jury, or there was some sort of fraudulent procedure in obtaining the true bill, that writ would issue. And it still very much exists in the federal court. In fact, in United States federal court now, after you've been convicted in state court or federal court, and the direct appeal process has been exhausted, if you're going to raise a challenge of, say, ineffective assistance of counsel, that's done through a writ of habeas corpus. So this tradition is very much still alive. The 5th one is called certiorari. Originally, this was just a command to another court to turn over its record for review to ensure that it didn't exceed the scope of its authority. Later, this evolved into the King's Bench had the ability to quash the lower court's decision if it violated a rule of law. And this became the basis in the United States for Supreme Court review of lower court cases. And then the 6th writ is not nearly as important. It's called procedendo, or proceeding. It's just an order for a case in another court to proceed to judgment. But the system is important because the royal courts versus the local courts is the original distinction between higher courts and lower courts in the United States. And the King's Bench would serve as the template for the US Supreme Court. And in fact, the judges of the King's Bench and of the Common Pleas were called justices, and there was a Chief Justice and 4 other justices. The judges of the Exchequer Court, interestingly, were called barons, even though they weren't titled barons. The other interesting and unique feature of English law is equity, which is something separate from law entirely. Appeal, again, here we're back to our French from appeler, which means to call. An appeal was a calling upon the king. The presumption was that his courts of law had applied the law correctly, but that there were extenuating circumstances in this particular case that justified deviation from application of the law. And this was an appeal to raw justice in its natural form, and hence it was called equity. The appeal was theoretically to the king himself, but as a practical matter, the king didn't hear these. He delegated them to his Lord Chancellor, which was sort of the chief administrative officer of the royal court. Prior to the Reformation, the Lord Chancellor was almost always a clergyman, a higher clergyman, usually a bishop, archbishop, or a cardinal, which meant they were trained in canon law, usually in Rome. And canon law was based on Roman law. So here I'm going to take a little digression and talk about Roman law. In the Republic and well into the Empire, the city of Rome had 1 judge for citizens and 1 judge for non-citizens. They were a senator elected who served an annual term. It was a political office just designed as a stepping stone to higher office. And the judge didn't do anything. It was a ceremonial role where the parties would swear an oath in front of him. And then criminal cases would go to a jury, which in ancient Rome was hundreds of citizens. And civil cases would go to a private arbitrator. Now, both, and the judge it was called a praetor. So both the praetors and the arbitrators, if they came across a sticky issue, would refer questions to private experts who were considered learned in the law. These were called jurisconsulta, and they would give written opinions, and the opinions would be registered, and often the key takeaways would be adopted by the praetors in the decree that they adopted at the beginning of their one-year term. And then the following year, the new praetor would adopt the previous decree plus any significant additions from the jurisconsults. And this led to decrees that were volumes and volumes long until the Emperor Hadrian issued what was called the Perpetual Edict, which codified all the decisions up to that time. And because of this edict nature of the legal principles, Roman law tended to be very maxim heavy. And that got reflected in equity jurisprudence in England. Two that I think of right away: he who seeks equity must do equity. That's a maxim that's called the doctrine of unclean hands, which means if you file a claim in equity, if it's shown that your conduct is inequitable, you're not entitled to relief. Another one is in Latin, de minimis lex non curat, or the law is not concerned with trifles. It means that if it's a technical violation, but if it's so minor that it really doesn't matter in the big scheme, there's no entitlement to relief. And if you ever hear the word de minimis used as an adjective, lawyers like to use it all the time. That's where that term comes from. Well, the equity court eventually, now switching back to medieval England, the equity courts gradually evolved to where the plaintiff, which in equity was called a petitioner, could plead directly into equity, where it was called a suit as opposed to an action. Currently, lawsuit and action are used interchangeably, but originally an action was a case at law in the law courts, and a suit was a plea in equity in front of the chancery court. And if you could show that you had no adequate remedy at law, you could plead directly into chancery. And in fact, that's still very much today a prerequisite for getting injunctive relief or any sort of equitable relief. You have to show that there's no adequate remedy at law, i.e. that you can't quantify these damages by money, and that some sort of non-monetary relief is warranted. And that's why corporate dissolutions, divorces are considered matters of equity, and you're not entitled to a jury trial, because originally they were not matters of law. It was a whole separate scheme pled into a different court entirely. I do want to talk a little bit about equity in law ran into a big controversy in the early 17th century, in the Earl of Oxford's case from 1615. It originally started out as a property dispute between the Earl and Magdalen College of Cambridge over who owned a piece of property. The case went before the King's Bench, where the Chief Justice, Sir Edward Coke, who I would consider reading about him further. He's one of the key figures in the development of the law of individual rights, at least as it existed in common law England, and would have, his thoughts would have major influence on American jurisprudence later. But he overturned a jury verdict for the Earl. Well, the Earl was not happy, and he pled into chancery, and the Lord Chancellor, the Baron Ellesmere, Lord Ellesmere, issued an injunction against enforcement of the King's Bench decision. And the issue came up, which court takes precedence? The King's Bench was the highest law court, but here you had the equity court telling it what to do. So King James I turned to his Attorney General, Sir Francis Bacon, the philosopher, who issued an opinion that equity took precedence over law because equity filled the lacunae, his term, in the law, and it was designed to apply to fact-specific situations that the law wasn't designed to address. So this effectively built the wall that to some degree still exists between equity and law in the English system. The House of Lords would become the final appellate court in England, but it didn't start out that way. Originally, under the theory that the king was present in in Parliament, both houses would hear petitions, the Commons and the Lords. The Commons stopped hearing the petitions in 1399, and the Lords by 1589. But James I revived the practice when there was a persistent litigant in his royal courts. He would direct his courts to refer the matter to the House of Lords because he didn't want his courts to bother with them. Then after the Restoration, this involved Lords hearing petitions regularly, but by the 1700, they would not hear any petitions unless the courts had considered them first. And thus it effectively became the highest court of appeal. And how it worked is not, even from the very earliest days, not every lord heard the case. What it was some of the more respected titles entitling them to sit in the House of Lords. And then they would sit as a subgroup called the Law Lords, and they would hear the cases there. It was effectively an appointment, a lifetime appointment to the highest court in the land, which for Americans will sound familiar. There's another body which those of you in Canada and the Commonwealth are certainly familiar with, is the Privy Council. And that is the monarch and the Lord President of the Council, and then whoever else the monarch appointed it. Traditionally, it's usually the heir to the throne, the archbishops of Canterbury and York, and any other trusted advisors the king has. Originally, it was just an advisory body on policy, but it eventually evolved judicial functions. One of its notorious ones was a committee of the Privy Council was called the Court of the Star Chamber, after the room where it met. And it started sometime in the 15th century and lasted until 1641, with the beginnings of the English Revolution. And it could inflict any punishment short of death without going through the normal judicial procedures. As a direct arm of the king, it was not subject to the King's Bench or its powers to review by writ. And then it retained jurisdiction over non-English possessions. In other words, if you were in England, you could petition the royal courts and go to the House of Lords. For colonial subjects, you had your local courts, but above them, you had no right to go to the King's Bench or the House of Lords. You went right to the Privy Council. And this was one of the major sticking points, one of the major grievances the colonists in the United States had against the British Crown. Before we get there, though, an important figure to mention is William Blackstone. He has an interesting life. He was licensed as a barrister, was not very successful in the practice of law, so he went into teaching, which is not how it works at all today. However, he was very successful as a lecturer. He had a very brilliant penchant for being able to condense complex and diffuse subjects into an organized, consistent explanation. And he collected these lectures into 4-volume, between 1765 and 1770, he published these lectures in 4 volumes called Commentaries on the Laws of England. And what this did was it systematized this haphazard, disorganized, complex, centuries-old body of English common law into an organized set of governing principles. The 4 volumes were the rights of persons, the rights of things, private wrongs, and public wrongs. This had never been done before, and it was a highly readable volume, and it established his success. He was eventually appointed a justice of the King's Bench and then of the Common Pleas. It made him financially successful as well, and it was hugely influential, not just in Britain, but I would say it was even more influential in the American colonies, because it allowed what was frontier territory at the time, without many access to printers or published volumes of the decisions of the courts. It allowed an easily accessible, readable compendium of English law, and it influenced the founders in coming up with a systematized volume of law in America. And in fact, Blackstone is one of the most quoted authorities to this day in the United States. And his commentaries aren't just, simple summaries. They get into the ideas of natural law and things like that. And let me see. I can't, my box is up here and I don't know if I'm here. Yeah, man considered as a creature must necessarily be subject to the laws of his creator, for he is entirely a dependent being. The law of nature, being coeval with mankind and dictated by God himself, is of course superior in obligation to any other. It is binding over all the globe, in all countries, and at all times. No human laws are of any validity, if contrary to this, and such of them as are valid derive all their force and all their authority, mediately or immediately, from this original. So here we have the concept of a natural law that is universal to all people in the world, and any law that contradicts it is not valid. That's pretty weighty stuff. And then, nothing is therefore more to be avoided in a free constitution than uniting the provinces of a judge and a minister of state. Here we have an advocacy for an independent judiciary. And then finally, this is perhaps one of his most famous quotations: it is better that 10 guilty persons escape than 1 innocent suffer. That's originally Blackstone. So moving on. Let's go across the Atlantic now. So the American colonies were, of course, settled from England, and they brought English institutions, including the courts, with them. Like England, they set up counties that had justices of the peace. They set up higher courts. And in fact, the trial level court in Pennsylvania and Ohio to this day is still called the Court of Common Pleas, even long after the English body has been abolished. And then they also include a reviewing court. These would evolve into the state supreme courts that every state still has today. The other interesting development in America is because of the lack of trained lawyers and the lack of court resources, law and equity in the same actions, and then the same courts would assume jurisdiction of both law and equity. There are still 4 states that have separate courts for law and equity, and those are New Jersey, Delaware, Tennessee, and Mississippi. And in fact, Delaware's is important because, as you know, something like 80% of major corporations are incorporated in Delaware, and all corporate governance and dissolution matters are filed there, and those fall within the Delaware Chancery Court, which is a separate court of equity that is devoted almost entirely to these corporate matters. So this does have present day application. So, pardon me. We have the Declaration of Independence that the colonies are free and independent states. State means a nation, i.e., there were 13 new countries. So they realized that some degree of unity was necessary if they were going to defeat the British Empire. So how were they to organize themselves? After the Continental Congress, the delegates sent from the colonies commissioned the committee to draft the Declaration of Independence. It also commissioned a committee of 13 with one delegate from each state to draft some sort of governing document. And what they came up with on November 15th of 1777 was the Articles of Confederation. Interestingly, the articles required all 13 colonies to ratify, or states to ratify. In 2 years, 12 did. Maryland held out until 1781 because the territorial claims west of the Allegheny Mountains in today's Midwest were unsettled, and it refused to ratify until that was decided, which it eventually did. But during the meantime, the articles were treated as a de facto constitution. How the articles worked is each state could send a delegation of anywhere from 2 to 7 members, but each delegation got only one vote. And the president of the Congress was appointed to a 1-year term, as were all the other officers of the Congress. And then the Congress had the power to declare war and conduct foreign relations, but 9 states were required to assent. The states could not form alliances with each other. And significantly, there was no national court system. Each state was in charge of its own justice. Well, it quickly became apparent that the articles weren't working. The 1-year terms and the term limits created an unstable and inconsistent policy. The state legislatures became all powerful, and in the area of commercial law was where this shortcoming was most keenly felt. 7 states issued inflated currency and then required creditors to accept it. And this led to a situation where creditors were literally fleeing their debtors. They also enacted extensions on farm mortgages, which again put creditors in a bind. And these moves were criticized as meddling in contractual rights and interfering in property rights, which there was the need to put a check on this freewheeling by state legislatures was one of the motivations for reform. And then also the national government was handicapped. There were proposals to impose a 5% tariff on imported goods to fund the national government, and then to create a national bank to regulate financial affairs. And both of these required unanimous consent, and Rhode Island defeated both with a single no vote. The last straw was a Shays Rebellion, where a retired Revolutionary War captain in Massachusetts organized a bunch of farmers. Massachusetts was one of the states that did not create any relief for farm mortgages. So he organized a bunch of farmholder debtors in an armed revolt, and the Massachusetts militia ended up putting it down. There were a total of 4 rebels killed. The ones captured had their death sentence commuted to prison sentences. But the whole rebellion and the inability of any other state to interfere in it created a popular perception that there was a need for reform. The one area, though, where the Congress under the Articles did achieve success was resolving those Western land disputes, and it enacted the Northwest Ordinance of 1787, which specified a minimum of 3 states in the area where I am now in the Midwest, Ohio, Indiana, Illinois, Michigan, Wisconsin. And it significantly banned slavery in that region as well. Originally 5 states around the Chesapeake Bay area, Maryland, Delaware, Pennsylvania, New Jersey, called a mini convention to propose amending the articles, but gradually other states sent delegates, and Madison and Hamilton prevailed to draft a new government entirely. And this led to the draft of our present Constitution. I could make a year-long course about the Constitution and all of its provisions and what they mean, but I'm going to focus now on the federal court system, federal authority, and the justice system. This is the Constitution as applied in the daily lives of most Americans. So, Article 1, Section 8 enumerates the powers of the federal government. The first one, tax and spend clause, and the third one, regulate commerce among the states. This is the most frequently cited basis for expanding federal power into areas that were traditionally reserved for the states. For example, the whole area of employment law, Title VII, the ADA, until the 1960s, that was totally reserved to state law. And in fact, as we'll see later, the federal courts routinely struck down even state regulations on employment. With the change in attitude in the 1960s, the Commerce Clause especially was used as the basis to justify federal oversight of areas of law traditionally reserved for the states. Another significant one in this part of the list is the section or clause 8, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This means the areas of patent and copyright law are exclusively reserved for the federal government. Trademark is a separate issue entirely. There was originally a Trademark Act passed that was struck down as not within Congress's authority under this clause because it didn't deal with an author or an inventor. However, later trademark laws were upheld in the 1870s under a series of Supreme Court cases called the trademark cases, with the Commerce Clause, the regulating commerce as a basis for federal trademarks. As long as a merchant or dealer could show that the mark was being used in interstate commerce, that justified federal regulation. And I would argue that that's one of the beneficial areas of the Commerce Clause. It allowed a consistent protection of ownership rights, really, across state lines. The second part of the list, these are rather specific. The one I have highlighted there is what's called the elastic clause or the necessary and proper clause. As we will see later, this very early on served as another basis for expansion of federal power into areas that were not enumerated elsewhere in this list. Article 2, Section 2 deals with appointments. The president appoints judges with the advice and consent of the Senate. That's why every time there's a Supreme Court vacancy, we get the dog and pony show within the Senate Judiciary Committee. The Senate has to approve the president's nominations for a federal judge to receive their commission. Article 3 governs the judiciary. Section 1 is jurisdiction, I'm sorry, it's not jurisdiction. Section 1 is the structure of the courts. There's the Supreme Court, which is mandatory. It gives Congress the power to set up inferior courts, and we'll see how it did that over the years. Judges hold their offices during good behavior, which means lifetime appointments, and they can't have their pay reduced while in office. Section 2 governs jurisdiction. All cases and controversies, this will be an important point I'll get to later, in law and equity. So the Constitution does recognize the difference between law and equity. Arising under the Constitution, laws of the United States, and treaties. This is what's called federal question jurisdiction. So if it's an issue that falls within the areas enumerated that I just showed you under Article 1, copyright, patent, interstate commerce, a federal law affecting interstate commerce, that automatically it doesn't have to go in federal court. You could file in state court, but a party will have the right to remove it into federal court and invoke what's called federal question jurisdiction. Or you could file directly into federal court. Controversies to which the United States shall be a party, i.e. suits against the government, and between citizens of different states. This is called diversity jurisdiction. So if you have X versus Y, and if you have multiple parties, and if no one on one side of the versus is a citizen of the same state, which means their residence or main office is in the other state, as people on the other side of the versus, that's what we call diversity of citizenship. And if the controversy is at least $75,000, or in theory could exceed $75,000 at the time of filing, the federal courts have jurisdiction, and you can either file directly into federal court, or if you're sued in state court and that criterion is met, you can remove the case in federal court, even if it only concerns a matter of state law. And state law will govern this, but the federal court will decide it. And as we'll see later, there's a reason for this, and there will be an important development in the law concerning this. And then it guarantees a trial by jury in all criminal cases, and trial must occur in the state where the crime is said to have been committed. Section 3 deals with defining treason. It's an important provision, but I won't get into that. So the supporters of the new Constitution, James Madison, John Jay, and Alexander Hamilton, wrote a series of papers in 1787 to persuade the public to support the new Constitution, called the Federalist. And Hamilton, in number 78, made this famous statement: the executive has the power of the sword, the legislature has the power of the purse, the judiciary has neither. All it has is, what's the term he uses? It just has their judgment. That's it. It has neither force nor will, but merely judgment, and must ultimately depend on the executive for its judgments to take effect. And in this way, he viewed the judiciary as the least dangerous branch, which is his exact words. He also advocates for judicial independence, echoing Blackstone, argues that and then here we go. He refutes the argument that the judiciary will be superior. He establishes that if legislation counters the Constitution, the courts must strike it down. This is establishing right away the power of judicial review over legislative acts. And then his reasoning is the power of the people is superior to both the legislative and the judiciary. Where the will of the legislature declared by its statutes stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter than the former. In other words, Hamilton views the constitutional supremacy as a matter of popular sovereignty. And then here we have sort of a praise of common law. To avoid an arbitrary discretion, it is indispensable that they should bound by strict rules and precedents. And to justify the lifetime appointment of judges, he says that being trained in this considerable bulk, he uses the words of precedent, demands study, and not very many people will have the competence to be judges, hence the lifetime appointments. In the remaining Federalists 80 through 83, Hamilton, he cites the example of the Holy Roman Empire, Emperor Maximilian I setting up a court to govern the various competing interests of the states. That is a chamber, was a chamber known as the Aulic Council, and it sat as a Supreme Court in an otherwise very loosely organized and decentralized state. And it was a well-respected body in its day, and Hamilton cited to its example. The excerpt from number 81 is an attack on the House of Lords, how a group of the legislative should not sit as the judiciary. Then we have number 82, the national and state systems are to be regarded as one whole, with the state courts as auxiliaries to the federal court. And then number 83 is just a general praise. The rules of legal interpretation are rules of common sense adopted by the courts in the construction of laws. And the true test is conformity to the source from which they were derived, i.e., the plain reading of the Constitution. I wish that were the case all the time. But here we can see what the goal was for the court system in the United States. I also think it's worthwhile to note some of the opposing viewpoints to Hamilton. There were criticisms of the judiciary as enshrined in the new Constitution. The main criticism was that the judiciary would be too powerful. In the number 80, you can see the citation to the writ. The quote goes on to cite the Writ of Quamanus as expanding the Exchequer Court's jurisdiction, and it argues, why wouldn't the same thing happen with the federal court system here? And as we can see in 81, the fear of expanding federal court jurisdiction would render the state legislatures and courts powerless and the states, pointless. Number 82, I think, is an interesting and accurate criticism. Is the Supreme Court obviously will sit in the seat of government, and if parties have to travel hundreds of miles with their witnesses and lawyers, no man of middling fortune can sustain the expense of a lawsuit. And the expense of a lawsuit is one of the main criticisms of the American judicial system to this day. And I can certainly attest to that. So what was called the Massachusetts Compromise was reached in December 1787 to January 1788, where the Anti-Federalists agreed to adopt the Constitution on condition that it issue a Bill of Rights. In Anti-Federalist 84, Robert Yates, who is the author of most of these, criticized if there's a limitation on the abilities, for example, to issue noble titles and issue ex post facto laws about that is prohibited under the Constitution, and if everything which is not given is reserved, why do they have these exceptions? Why is there no statement of what rights are retained and where the limits of the federal government stop? So this bill, originally there were 12 proposed amendments, 10 of them were adopted. The remaining 2 amendments eventually would be adopted. But the First Amendment, freedom of religion, speech, press, assembly, petition to government. 2, the right to bear arms. 3, no compulsory quartering of soldiers in houses. 4, the prohibition on unreasonable searches and seizures and probable causes required to issue a warrant. Number 5, the indictment by grand jury is required for certain criminal charges. There's a prohibition on double jeopardy. You cannot be charged twice. Prohibition against self-incrimination. You can't be compelled to testify in a criminal charge against you. Due process of law required to deprive a person of life, liberty, or property. And no property is to be taken without just compensation. That's a lot. The Sixth Amendment, in criminal cases, you have a right to a speedy public trial by jury in the district where you're charged, the right to confront witnesses and to counsel. 7, the right to a jury trial in civil cases. Article 8, the prohibition on cruel and unusual punishments or excessive fines or bail. And then 9, the enumeration of rights is not to be construed as a denial of others. This amendment is kind of dead. This has never been applied by the US Supreme Court as the basis for any other right. And we'll see where these additional rights arise from. And then number 10, powers not delegated to Congress or prohibited to the states are retained by the states. So that establishes the federal system and was intended to serve as an explicit statement of where the federal government's powers were limited. So early developments in the federal courts, after the Constitution was ratified, the first Congress in 1789 passed the first Judiciary Act. It set up a Supreme Court consisting of a Chief Justice and 5 Associate Justices. In 1807, this was expanded to 7. In 1837, it was expanded to the 9 we have today. Then from 1863 to 67, it fluctuated between 10, 9, and 8. And then finally in 1869, the number was fixed at 9, where it stands today and where it stood ever since. Washington's appointment as first Chief Justice was John Jay, the author, one of the Federalist authors. His other appointments included James Wilson of Pennsylvania, who was one of the key drafters of Article 3, and the Massachusetts district in each state, except for 2 in Massachusetts and Virginia. It set up a circuit court in a circuit court and a district court in each state. The circuit court and appellate jurisdiction over the district court. And then the district court had a separate judge who was a permanent appointment, and it heard admiralty cases, federal misdemeanors, and suits by the US of less than $100, which at the time was a lot of money. So for the first 100 years of the Supreme Court's existence, each justice would preside over jury trials in the circuit court in his circuit. And then for a term, for 2 terms in the year, return to DC and sit together, which in law we call en banc, and hear the appeals, including those from the trials that he heard. In this way, it functioned very much like an English court, which was the basis the founding fathers were working from. The very first landmark case the court heard was called Chisholm versus Georgia in 1793. And what you have there is the citation. I'm giving you the citations because if you go to Google Scholar and type that in, if you're so inclined, you can actually pull up these opinions and read them yourself and note the change in style over the years. The early opinions are very unreadable. And you can sort of follow the court's reasoning yourselves and read the dissents and concurrences that I'm not going to get into here. But this was a suit by citizens of South Carolina against Georgia, and Georgia asserted the traditional defense of sovereign immunity, where the king was immune from suit unless he consented to be sued. And the state argued that it stood in the shoes of the king. And the Supreme Court held that, yes, the grant of jurisdiction to the federal courts over these lawsuits meant that it effectively abrogated the doctrine of sovereign immunity. Well, this created an uproar, and in response, Congress passed, and the states ratified the 11th Amendment, which restored sovereign immunity to the states. So to this day, you cannot sue a state or a state actor unless the state has consented to be sued. There's a legal fiction that gets around this, and I'll get into that in a second, but that traditional rule is still very much in force. The J Court is also significant for establishing what we call justiciability. The clause in Article 3 that grants jurisdiction over cases and controversies, the court has interpreted as being, if there's no actual dispute, we don't have jurisdiction to hear it. And this started in a letter from George Washington where he asked John Jay if his court would give opinion on matters he was dealing with that were likely to come before the court. And Jay responded in a letter saying, "Thank you for the confidence in us, but we fully trust your ability to handle this. And in any event, our jurisdiction is limited to cases and controversies, so we can't issue what's called an advisory opinion, which is an opinion from a court on an issue that's not before it." Now, interesting state has an analogous provision, so some state courts are fully able to issue advisory opinions. But in federal court, you can't. And this cases and controversies limitation extends well beyond just advisory opinions. For example, the whole issue of standing on government, claiming only harm to his and every citizen's interest in proper application no more directly and tangibly benefits him than it does the public at large, does not state in Article 3 case or controversy. So you have to have an actual stake in the outcome of the matter. Ripeness, that means, and again, quoting Texas versus US, a claim is not ripe for adjudication if it rests upon contingent future events that may not occur as anticipated or may not occur at all. In other words, it can't be speculative damages. And then mootness, the case has to actually be alive. The case I have there, diffunis, the litigant was challenging denial of his admission to law school under an affirmative action policy. But by the time it got to the Supreme Court, he was in his last semester and going to graduate. And the Supreme Court said, there's nothing for us to adjudicate here because the dispute is moot. And mootness, I know in Commonwealth jurisdictions means something totally different. In United States federal court, and in most state courts as well, it governs the court's jurisdiction. And then we have abstention, where even if a federal court has jurisdiction, there are certain situations under which it will not adjudicate the case. And the 4 cases I have here, Pullman abstention is when there's an issue of the constitutionality of state enactments, and the state courts haven't yet had a chance to make a pronouncement on them in a way that could moot the case in federal court. Younger abstention bars civil rights suits when there's still an active prosecution in state court. Burford abstention is even more deferential to state courts. If it involves a question of state law that has policy concerns, and federal intervention would disrupt the state from establishing a coherent policy, the courts will abstain from the case. And then Colorado River abstention exists where there's parallel state and federal cases, and the determination of the state case could affect the outcome of the federal case. So there's this very elaborate interplay between state and federal courts that you'll see coming up again and again. One of the most influential figures in American law is Chief Justice John Marshall, who was appointed by John Adams and served for the remaining 34 years of his life. The key case he had was Marbury versus Madison. And even though Alexander Hamilton and even the J Court, several times acknowledged the ability of the Supreme Court to strike down legislation as unconstitutional, Marbury versus Madison was the first time the Supreme Court actually did it. It's an interesting case. What happened was Adams was defeated by Jefferson in the 1800 election, and back then the new president wasn't inaugurated till March. So Adams made a flurry of last-minute appointments, including these for a commissioner, which is like an assistant judge in the District of Columbia. His outgoing Secretary of State, who happened to be John Marshall, didn't deliver 5 of the commissions, one of which was due to Mr. Marbury of Maryland. So when Jefferson took over, his Secretary of State, James Madison, refused to deliver the commissions, arguing that the commissions were void without delivery. So Marbury sued in the Supreme Court under a statute that gave the Supreme Court original jurisdiction over writs of mandamus, following the English model of the King's Bench. Well, Marshall was faced with a situation where if he found for Marbury, it would effectively be seen as a political decision against the administration that replaced his Federalist supporters. But instead, he turned to the act of Congress that authorized the Supreme Court to issue writs of mandamus and said, the conferral of original jurisdiction, the Constitution didn't include a provision for mandamus. Therefore, Congress exceeded the scope of its authority, and the statute under which Marbury brought his lawsuit was unconstitutional, and therefore Marbury lost. And that firmly established the principle of judicial review and the court's ability to strike down statutes as unconstitutional. The other thing Marshall did around this time was, up until, in the English courts and in the American courts up until him, every justice of the court wrote an opinion on a case. So at the time, there were 7 justices. You would get 7 short opinions, and you'd have to figure out where the majority fell to decide what the judgment was. Marshall changed that and delivered a single opinion for the whole court, which was a new development at the time. And obviously, if a justice dissented or concurred, they would write separately, but that he established that practice of a single opinion for the court. The other key decision Marshall made was McCulloch versus Maryland. This dealt with Congress's establishment of the Second Bank of the United States. Maryland and other states saw this as an encroachment on their power, and they fined any bank that would issue notes not stamped with their state Treasury Department stamp. And so a Maryland branch of the Bank of the United States issued notes without the stamp. The case went through the Maryland courts, and Maryland upheld the fine. Well, it got to the US Supreme Court, and Marshall overturned it under the necessary and proper clause. Even though the power to create a bank wasn't specifically enumerated in Article 1, Section 8, the necessary and proper clause conferred implied powers not enumerated. And to quote from the decision, "Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and the spirit of the Constitution, are constitutional." Had that case gone the other way, it would have severely hampered the ability of Congress to enact legislation beyond the strict limits of Article 1, Section 8. And the debate over how good or bad of a thing that is continues. Cohens versus Virginia established the power of the United States Supreme Court to review decisions coming out of state Supreme Courts. The reasoning is if you didn't do that, it would effectively give the state courts a veto over application of the Constitution to state laws. In recent years, the Supreme Court has required there to be a separate and independent basis under the federal Constitution for that power to be exercised. But the Supreme Court still has the power to review decisions coming out of state Supreme Courts. And then Barron versus Baltimore at the bottom is important because it held that the Bill of Rights only applied against Congress, not against the states, which leads us into our next discussion, the Civil War amendments. The 13th Amendment abolished slavery. The 15th Amendment guaranteed rights of citizenship to former slaves. But the 14th Amendment, which was ratified in 1868, is the key, the most important of those three. It completely revamped the constitutional order that was set up in 1789. Section 1 is the key component. No state, so now we're incorporating rights against the states, shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protection of the laws. So those three clauses, privileges and immunities, due process, equal protection, there's a whole developed body of case law addressing each of those. The privileges and immunities clause is kind of a dead in the water. The slaughterhouse cases of 1873 held that privileges and immunities clause protects only rights guaranteed under the federal Constitution. So it pretty much duplicates the Bill of Rights. Was found under this clause in 1999. I'll get back to privileges and immunities in a minute, but the due process clause under the 14th Amendment has been held to be divided into procedural and substantive elements. Procedural due process is right to notice and a hearing before there's any deprivation of, or I should say notice and an opportunity to be heard before there's any deprivation of life, liberty, or property. And that's the same as guaranteed by the Fifth Amendment. But the deprivation of liberty without due process led to a development of a doctrine known as substantive due process. And it's hard to sum it up in a way that makes sense. It was originally held to protect an absolute right to contract. In other words, the deprivation of liberty without a court proceeding was held to apply to economic regulations. And the Allgaier and Lochner case came from an era of what we might call the Gilded Age, the capitalist era, where regulations on employment and things like that were seen as undesirable, and such regulations by states were struck down as violating the right to contract. After World War II, the substantive due process, well, during the New Deal, I should say, this sort of substantive due process as applied against commercial regulations fell out of favor. But the doctrine didn't die. Instead, it turned to social regulation. And the first real case to apply this was Griswold versus Connecticut in 1965. It struck down a ban on the sale of contraceptives based on a right to privacy. And the author of that opinion is pictured here, William O. Douglas. He is the longest serving justice on the court and one of the worst, in my opinion. I think his writing and his reasoning are sloppy. And Griswold is sort of the epitome of that sloppiness. He held that the rights enumerated in the Bill of Rights contained emanations that cast penumbras. Those are his exact words, that defined other rights. And this is where he found this right to privacy to exist. And this would serve the basis for Roe versus Wade 8 years later. As you can see, Lawrence versus Texas dealt with struck down criminalization of homosexual acts, and Obergefell versus Hodges struck down, or mandated rather, states to allow marriages between persons of the same sex. This all fell under the right to privacy that developed out of the substantive due process case law. And most opponents of its application citing on which it first existed, the emanations and penumbras language. Today, I'm trying to not to be too controversial about the topic. The other element of the due process clause is incorporation. The 14th Amendment is the vehicle by which the bill guarantees that the Bill of Rights are incorporated against the states. However, there was no decision incorporating the entire Bill of Rights, and the case law that developed, again, under cases and controversies, it has to be on a right-by-right basis. Otherwise, the Supreme Court would be violating the cases and controversies requirements. So when we have incorporation of the various First Amendment rights, that's all done on a case-by-case basis. And there are 5 cases stretching from 1925 to 1947 that piecemeal incorporate the First Amendment against the states. The Second Amendment wasn't incorporated until 2010. The quartering of soldiers under the Third Amendment, that's never been an issue that the Supreme Court has addressed. The Fourth and Fifth Amendment, you can see that those during the years of the Warren Court in the 50s and 60s, when protections against criminal procedure were incorporated against the states in a flurry of cases. You can see there's a whole detailed body of Sixth Amendment jurisprudence. And then the most recent incorporation is the prohibition against excessive bail and fines, which came out of Indiana here. And that was decided 3 years ago. And there's been no holding on the Seventh Amendment either. So this is very much an area still in flux. And interestingly enough, there's a principle of reverse incorporation, which was articulated in Bowling versus Sharp. That's where the Supreme Court ordered desegregation of the DC public schools. Even though DC was federal property and the 14th Amendment didn't apply to it, they held that the due process clause of the Fifth Amendment incorporated the protections of the 14th Amendment against it. So the 14th Amendment through the Fifth Amendment applies against the federal government as much as it does against the states. And then back to the privileges and immunities, Justice Clarence Thomas in the most recent incorporation holdings prefers the incorporation to fall under privileges and immunities rather than due process, the due process clause. I mean, he still accepts the idea of incorporation, just challenges the basis for it. Right now, it's a minority view, but you may see a shift in that given the current composition of the court and where we might be headed. Finally, we have equal protection, and this is designed, Strotter versus West Virginia. It was designed to ensure that Black Americans received the same protection of the laws that white Americans did. This developed into an elaborate tiered analysis that was first theorized in actually the footnote of a decision in 1938, the Caroline Products. And that footnote 4 is cited in a whole flurry of cases that followed. There are 3 levels of scrutiny. There's strict scrutiny, which is applied when there's a suspect classification, usually race, or a fundamental right at issue. And to survive that, the law at issue, the state action must be the least restrictive means, narrowly tailored to a compelling government end. At the opposite end is rational basis, which, as long as the state action is a rational means to a legitimate government end, it will survive. And then intermediate scrutiny was created later in the 1980s. And it applies to distinctions based on sex. We're not going to get into gender and all the implications that has, but in the 80s, there was still this notion that there are 2 sexes, and distinctions based on them had to be substantially related means to an important government end. And another landmark case we have is Plyler versus Doe, which used the phrase within its jurisdiction, equal protection, the state must guarantee equal protection to persons within its jurisdiction. This was meant to work around the argument that freed slaves weren't actually citizens. Well, the Supreme Court used that language to hold that equal protection applies to anyone, quote, citizen or stranger who is subject to the laws of a state and reaches into every corner of a state's territory, i.e. this was used to hold that the children of illegal immigrants or illegal aliens were entitled to public school education in Texas. Again, that's a controversial issue, but as Plyler stands, the equal protection extends to non-citizens as well. The statute that enforced the 14th Amendment is codified at 42 United States Code section 1983. It's called, well, it was called the Ku Klux Klan Act when it passed. Today, we just call it section 1983, and everyone knows what you're talking about. Every person who, under color of any statute, etc., of any state, territory, or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding, etc. So this creates the legal fiction that when you have a state actor who is violating civil rights, he is no longer acting on behalf of the state and is instead acting under color of state authority. That you get around the arguments of sovereign immunity, because ordinarily at common law, there's a rule called respondeat superior, where if you're an agent of an employer, you are not individually liable, the employer is liable for the actions of its agent. Well, in the case of sovereign immunity, you create the fiction that the individual actor is now separated from the state. So you have, let's say, a suspect who's beaten up and tortured by the police, or someone whose tax return has been audited as harassment by the IRS. You don't sue the state, you don't sue the city of New York, the city of Chicago, the state of Illinois. You sue the individual police officers. You don't sue the United States. You sue the individual agents under 1983. And every state and the federal government has provisions that they pay for the defense and the judgments. So in effect, it's a lawsuit against the state. It just can't be called that, because if you sue the state or the government, it'll be dismissed under 11th Amendment sovereign immunity. But if you sue the individual actor and allege that they were acting under color of state or federal law, guess what? You have a viable lawsuit. Distinction without a difference, but it's an important one, which shows us that legal fictions still survive and are with us. Now, some reforms. This started early on with the state courts under Jacksonian, what we call Jacksonian democracy. The idea of the people as the ultimate sovereign led to states amending their constitutions, starting with Mississippi in 1832 to provide for elected judges, even at the Supreme Court level. And in fact, to this day, about half of the states still elect their judges, some in partisan, some in nonpartisan elections, but it's still very common. And if you go to, for example, Michigan and Wisconsin, this time of year, you'll see campaign posters for state Supreme Court, state Court of Appeals. The other development, and then there was a shift away from this in the mid 20th century, starting with Missouri. They developed a hybrid plan where judges are nominated by candidates are nominated by a commission appointed by usually the governor, and then subject to a yes/no retention vote by the people every so many years. That's called the Missouri Plan. I'd say about a third of the states have adopted something similar to that, including obviously Missouri, Indiana, Florida, California. Most of your states out west have something like that. The other development is a three-tiered court system where originally you had, in most states, you had the distinction between, you had your trial courts, and then you had a court that heard appeals, but called the Supreme Court or something similar. Well, as the population grew and disputes grew, the highest court's docket became so crowded that states began developing an intermediate court where appeals would either be brought there, and then the Supreme Court could review those cases if there was any error of law at its discretion, or in other cases, appeals would be brought to the Supreme Court and then would hear what it wanted to and refer everything else to the mid-level court. The first state to do this was Illinois in 1877 when it created the appellate court. Louisiana created its mid-level appellate court 2 years later. And then Indiana, Texas, and Colorado created a mid-level court in 1891. And that's when the federal government, Congress took action. There had been complaints about the Supreme Court justices riding circuit. They were mostly elderly men, and the stress of going around the country, particularly in reaches far from DC, put stress on them. It delayed hearing of trials and of appeals significantly. But there were arguments in favor of it. Its supporters thought that it brought the justices closer to the people and brought them to, parts of the country where they otherwise ordinarily wouldn't go. But in 1891, that was settled. The federal government adopted the three-tiered system where you have the 10 existing circuits, and 11th would be added in the 1920s. Each justice would be assigned at least one circuit as a circuit justice to hear matters that only required one justice, like granting a stay or certain injunctions or habeas corpus relief. Otherwise, all appeals would be brought to a circuit court, which had its own set of circuit judges and would hear the appeal as of right within that circuit in panels of 3, with the option to petition for what we call an en banc hearing with all judges of the court, which didn't have to be granted. And then from there, if there was an issue with the circuit court's decision, the Supreme Court had certiorari review at its discretion over the circuit court. So and then the district court was transformed into a full-blown trial court with full jurisdiction. So the way we have it now, is there's a district court, and you can see the districts on this map too outlined. You have a district court with trial jurisdiction. You have a circuit court with appellate jurisdiction, with the Court of Appeals for the First Circuit, the Second Circuit, etc. And then you have the United States Supreme Court, which has discretionary review over all decisions of the Courts of Appeals. Later, two other reforms were added. Magistrate judges were created in 1968 to replace the commissioners originally created. They have the authority to issue warrants, hear pretrial proceedings, and then they can preside at civil trials with the consent of the parties. Those are designed to relieve the district judges of their caseload burden. And then in 1978, bankruptcy courts were created, again, to relieve the district judges of their bankruptcy caseload. Because remember, federal courts have jurisdiction over all bankruptcy proceedings. And this is by far the bulk of the federal docket. So there is a separate set of bankruptcy judges appointed to hear those. However, neither magistrate judges nor bankruptcy judges are considered Article 3 judges. They're appointed for limited terms. The other reform that came was under Ronald Reagan. A new circuit was created. You can see the black dot on the screen. It's next to DC. There's a circuit for DC, which is quite powerful, even though it's not geographically broad. That hears, it has jurisdiction over cases involving, or appeals from cases usually involving Congress and government actions and administrative actions. But the other dot you see there, it says Fed. That's the Federal Circuit, which was created in 1982 under Reagan. Before then, patent cases went to their individual geographic circuits, and you could in some cases get a split in authority over whether a patent was valid under a given set of circumstances or not. So this Federal Circuit was created with nationwide jurisdiction over patent cases, patent appeals, to create a uniform body of intellectual property law as it applied to patents. So there was no question over whether your patent was valid depending on what part of the country you were in. That is generally viewed as a positive development by inventors and holders of intellectual property. There are also procedural reforms I want to get into a little bit. We have the complex system of common law pleading that we discussed. That was adopted wholesale from England, but there was right away a recognition that the reforms were needed. The key words and the legal fictions were seen as antiquated and frankly stupid. So Louisiana, though, adopted a civil code on Spanish and French models. The Napoleonic Code was one of its influences. Remember, civil law is where you codify everything, and Louisiana is still unique in that it follows a European-style civil system. David Dudley Field, who you see there, was a New York legislature inspired by Louisiana's civil code, convinced the New York General Assembly to adopt a code of civil procedure in 1850 that replaced the old common law regime. And one of its most significant achievements was to abolish the system of writs and instead created a single form of action known as the civil action, where you could request any claim for relief, and it was up to the courts to recognize it. And this led to courts, discovering or recognizing causes of action that hadn't existed before. And the other thing it did was it emerged equity and law into this single civil action. In other words, there was no separate plea or suit at equity and action at law. There was a single civil action where you could request equitable and legal relief at the same time. California followed in 1851, and by the end of the 19th century, every state had adopted its version of code pleading. The federal government, the federal courts as usual, were slow. In equity cases, they adopted rules of equity procedure under the theory of their inherent authority to govern proceedings before them. And then the reform movement gradually caught on. And then in 1934, Congress passed an act requiring federal courts to follow state procedure, which effectively abolished common law and pleading in federal courts. And then in 1938, the Supreme Court enacted the Federal Rules of Civil Procedure, which are rules of procedure not adopted by code, but rather by the court. And those have remained fairly consistent for the last 80 or so years. And following suit, many states adopted court rule pleading as opposed to code pleading. So some larger states that have retained the code pleading system are California, New York, Illinois. States that have moved toward a rule pleading system modeling the federal rules include Florida, Michigan, Indiana, Georgia. I think Georgia, I'm not sure about that. And then finally, there was a significant landmark case, Erie Railroad Company versus Tompkins. This dealt with the issue of diversity cases, where it was a lawsuit between citizens of states that state law governed, but the federal courts had jurisdiction of based on the diversity of citizenship. Each circuit developed its own common law. They said, we're not bound by the state courts, so we're going to decide this on our own cognizance. And you had each circuit developing its own body of legal precedent, applying different state law. And this created a haphazard system that led to forum shopping. And then in 1938, the United States Supreme Court, in an opinion authored by Justice Brandeis, put an end to that. They said, if in diversity cases, you apply the law of the state as interpreted by the highest court of the state. So, and highest court, not the mid-level appellate court. So what frequently will happen is if a state comes in federal court and the highest court hasn't pronounced a decision on it, the federal judge or the judges in the case of an appellate panel will what we call certify the question to the state Supreme Court, saying, you don't have any body of decisions on this. How would you decide this issue? And because most state courts don't have a prohibition on advisory opinions, or the case does involve an actual case in controversy for states that do, the state Supreme Court doesn't have to, but it will in most instances issue an opinion and give the federal court guidance on how to apply the state law in that case. So what this system has produced some nice results. The first luminary you have here is Joseph Story. He was a key member of the Marshall Court. One of his most significant accomplishments is writing a familiar exposition of the Constitution of the United States. And as you can see, it's a fairly thick book at an early stage where not a lot of case law had developed on the Constitution. So his view, this is considered one of the most authoritative texts on the Constitution from the early period in American history. The other thing too is Joseph Story was from Massachusetts, and he sat as circuit judge in New England, which was the most rapidly developed industrializing part of the country. So he developed early the law of patents and trademarks in its early stages. And he's still one of the foremost authorities on American intellectual property law. The other judge you see here is Learned Hand, which is his real name. And he was on the Second Circuit from 1924 to 1951. He was never appointed to the Supreme Court because he was a Republican when Franklin Roosevelt and Harry Truman were presidents. but he is the most cited Court of Appeals judge in the United States Supreme Court to this day. And his opinions are revered for their clarity and their almost in fact, pure mathematical analysis in many cases. And when lawyers talk, when we say unflattering things about a judge, we'll often say, "Oh, he thinks he's learned at hand," or that's meant. He's still well known to this day for his achievements. And there are low points. As everyone may know, there's the Dred Scott case from 1857 that involved a slave owner from Missouri who lived in Illinois, which was a free state, with his slave. And then he died, and then his heirs in Missouri demanded return of the slave for the last few decades. And in an ill-advised move, the Supreme Court it heard the case on direct appeal at that time, and held that the estate, the former, if you want to call him that, slave still belonged to the heirs of his owner, and that living in a free state didn't matter. And then it went ahead and struck down the Compromise of 1850 under the theory that it was hoping to settle the slavery debate once and for all, when all it did was make things worse and accelerate the Civil War. Then there's the Plessy versus Ferguson decision of 1896. It involved a segregated public transport in New Orleans. It was challenged by Black users of the system. And again, the Supreme Court passed on it. It held separate but equal was not, the theory of separate but equal was not a violation of the US Constitution. And then it's kind of a brazen opinion. The argument consists in the assumption that enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything, but solely because the colored race chooses to put that construction on it. I mean, then there's the Buck versus Bell decision of 1927, authored by Oliver Wendell Holmes Jr., son of the poet, otherwise a well-respected jurist, but that involved forced sterilization of someone adjudicated to be mentally incompetent, and in his infamous line, 3 generations of imbeciles are enough. And that was an 8-1 decision. And then Korematsu versus the United States, that involved a suit by Japanese US citizens of Japanese descent who were interred during World War II. In a 6-3 decision authored by Justice Hugo Black, they held that Korematsu was not excluded from the area because of hostility to him or his race. Essentially, it was a deferential decision to our military leaders. Congress reposed confidence in this time of war, as it inevitably must, and determined that they should have the power to do just this. Recently, the Supreme Court went out of its way to reverse the Korematsu decision, even though the issue wasn't really before it, but it still stands as one of the hallmarks of one of the Supreme Court's bad decisions. I don't know, Matt, do we want to take a break before I move on to Plato? I know that was kind of extensive, or should we launch right into it?
Well, from what I understand, Adam, you had in your mind 2 presentations, right? That this Gestalt was divided into in sort of 2 chapters. Is that correct?
I was going to devote the second one to another one, but if you want, we can split it here. It's entirely up to you.
I would
normally is much shorter than the one I just presented.
How long do you think it's going to be? Just because I have a family thing for Thanksgiving in a bit.
Oh my gosh, I've been here for 2 hours.
It's okay. I mean, if you what do you think? If you did do this?
I'll run through it in 10 minutes.
10 minutes? All right, 10 minutes. And then everyone should have their questions in mind. We'll have about maybe 25 to 30 minutes of Q&A time. So yeah, go for it, Adam.
All right, so the Laws is Plato's final and longest dialogue, and it's also the only one not to feature Socrates as a character. And it has an interesting background that's gleaned from what a seventh letter that's attributed to Plato, and is the only one that some scholars say might be legitimate. But Plato went to Syracuse, a Greek city in Sicily, which was under the tyrant Dionysius the Elder, and he befriended the tyrant's brother-in-law, Dion. During his second visit, Dionysius the Younger, Dion's nephew, was now tyrant, and Dion hired Plato to tutor the new tyrant, and Plato also gave advice to Dion's followers. Now, Dion didn't like his nephew, who he viewed him as sort of dissipated and luxurious. And Plato was suspected of disloyalty, imprisoned for a bit, and eventually expelled. Plato returned a third time to Syracuse to see whether Dionysius the Younger had learned anything, and was disappointed. He returned to Olympia. Then Dion came to him and said he was preparing for an invasion to overthrow his nephew, and requested Plato's support. Plato refused because he had been Dionysius the Younger's guest and saw it as inappropriate. Dion did invade, overthrew his nephew, reigned as tyrant for 3 years, and then was assassinated by a student of Plato named Callippus. And Syracuse fell into anarchy. Dionysius the Younger would return for 2 more years before being expelled again. And then eventually Timoleon would emerge as the new tyrant. But the Laws, Plato wrote the Laws in retrospect of this experience. In fact, he comments in the Laws that hindsight is 2020, and the Laws is the view of a seasoned, somewhat cynical viewpoint who's had real world experience. It's a dialogue with 3 participants and a nameless Athenian instead of Socrates. Cleinias, who is a Cretan from Knossos, and then that's Cretan from Crete, and Megillus, a Spartan. All of them are described as old men, in contrast to the Republic, which is a dialogue between Socrates and young men. And it's placed in Knossos in Crete. And in fact, the 3 old men are walking the route that King Minos was said to have taken from Knossos to a grove where Zeus dictated his laws to Minos. In contrast to the Republic, which is more of a thought experiment and in a view of theory, the Laws is very much grounded in reality and in practical virtue, and virtue being the concord of reason and emotion. The neglect of the rule of proportion leads to arrogance and injustice, and a legislator's job is to have this sense of proportion. And the lawgiver should frame his code with an eye to 3 things: freedom, unity, and wisdom, the title of this presentation. Illustrating the pragmatism of this view, the real difficulty is to make political systems reflect in practice the trouble-free perfection of theory. I think that's a silent allusion to the Republic, which is the perfection of theory. Later in the dialogue, Plato has his characters say, "But I believe that in every project for future action, when you are displaying the ideal put into effect, the most satisfactory procedure is to spare no detail of absolute truth and beauty. But if you fight on one side and not attempt it, you should see which of the remaining alternatives come closest to it and is most nearly akin to your policy, and arrange to have that done instead." Eminently practical. touching on virtue, we should run our public and our private life, our homes and our cities, in obedience to what little spark of immortality lies in us, and dignify this distribution of reason with the name of law. But take an individual man or an oligarchy or even a democracy that lusts in its heart for pleasure and demands to have its fill of everything it wants, the perpetually unsatisfied victim of an evil greed that attacks it like the plague. Well, if a power like that controls a state or an individual and rides roughshod over the laws, it's impossible to escape disaster. And I cannot but help find in this a reflection of the quote by John Adams: "Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other," i.e., no laws is going to keep your society in order if the people themselves don't have any moral principle guiding them. Plato advocates the supremacy of the law. And again, we have a reflection of natural law here. When law protects a portion of the community, it's not a law. Its lawmakers are not citizens, but party men. Laws not established for the good of the state are bogus. Rulers must be servants of the law. And where law is the master of the government and the government is its slave, the state is full of promise. Otherwise, collapse is not far. And elsewhere in the dialogue, Plato says, when a state collapses, who but the rulers are to blame? So Plato goes a lot into art and aesthetics, particularly music. I'm going to stay focused solely on the laws, and Plato constructs a system here. And you'll notice a lot of these are actually adopted in the United States currently. Plato says laws should have a text and a preamble to persuade of their necessity. Well, almost every piece of legislation that passes includes a preamble consisting of findings on why the law is necessary. I'm municipal attorney for a town here. Even in the town ordinances we pass, they begin with a preamble stating why we're enacting this. It doesn't have to, but the legislative body is explaining itself. This is standard practice. Plato also envisions 3 grades of courts, exactly like involving appeals to a third and final court, which he envisions as a sort of Supreme Court. A justice of the Indiana Supreme Court said in a private conversation I was involved in once, we're not last because we're right because we're last. That's the sort of system Plato envisioned, and we have the 3-tiered vision he discussed. He envisioned a trial by jury. As for crimes against the state, the first need is to let the man in the street play his part in judging them. Plato also foreshadowed Blackstone, who envisioned a crime consisting of a bad act and a bad mindset, or actus reus and mens rea. Plato envisioned this as a voluntary act and an involuntary mental state. And because crime was involuntary, a punishment was a cure for it. That didn't bar things like the death penalty in his mind, but punishment was a disease, or crime was a disease and punishment was a cure. And interestingly enough, he also established the office of scrutineer to investigate and publish public officials for misconduct in office. Athens had something similar, but Plato envisioned something more broad. And in fact, Plato in this work actually criticizes the Athenian constitution for delving too close to mob rule. He has his characters. The Athenian character praised the Spartan constitution, which Plato says preserved the balance between the powers, the 2 kings in Sparta, the 5 ephors who were annually elected officers who oversaw the kings, and then the council of elders, or the Gerousia, who conducted foreign affairs and had veto power over the assembly. And then in his closing remarks, Plato comments the necessity of philosophy for lawgivers. he cites two principles that, or two doctrines rather, that must be embraced. The soul is immortal and controls the world of matter, and reason is the supreme power among the heavenly bodies. And then he admonished lawmakers to study philosophy. He must use his power of reason to frame consistent rules of moral action and explain them. And no one who is unable to acquire these insights and rise above the level of the ordinary virtues will ever be good enough to govern an entire state. So with that, I will let each of you judge the degree to which the American system is consistent with Plato's vision, but I would argue it was vastly an improvement from the haphazard English system, and probably continues to come closest among any of the constitutions today. And there are those, even Supreme Court justices who want to advocate something different along international norms and the like. But we're always at risk of losing that, and we need to keep our first principles in mind, not only of the founders but of Plato, whom they all read and knew and loved. So with that, I'll turn it over to any questions anyone has.
Thank you, Adam. That was comprehensive, and what an amazing introduction to law in the broadest and also most specific sense. So you balanced out the universal and the specifics in a really wonderful way. I'm really glad that we have this as especially a resource document to be returned back to. And the ending, I'm also glad just to say that I gave you the space for that final powerful ending on Plato and the laws. That was vital. It would have been terrible if we didn't do that. Okay, so we have time for a couple of questions, and maybe two, maybe three. Peter was the first to get in there, so Peter, it's all yours.
Thanks, Matt. And Adam, I really commend you for your comprehensive historical view, commencing with William I and going step by step, through the American experience of law. And I just want to share a piece of trivia. If you can recall old episodes of Perry Mason, there's a bust of a distinguished fellow at the door. That is Blackstone. For what it's worth, that's Blackstone.
The other thing about Perry Mason is, if you notice, none of those cases go to trial. They're all decided at a preliminary hearing.
Indeed, they are. And we could talk more about that, but I hope you have an outline for this, because this would make a great continuing ed seminar, and it's unlike any that I've ever experienced. So jumping right into my questions, under American law, how did corporations become people, and how did money become speech?
Good question.
Well, that goes back to English law, and corporations are people. It was originally designed to protect the investors, and I don't think it's a rule that should be changed. In other words, the corporate form is available. If you want to invest in it, you are limited only up to the amount of money you put in, and if you're sued, you can't be taken for more than what your investment is. And the whole idea of a corporation as a separate body protects those who invest in it from personal liability. And there are exceptions to that. For example, if you don't segregate funds, if you don't follow your corporate bylaws, keep minutes, things like that, they'll toss aside a court will toss aside the corporate personality and say it's really just a shell for the individual. But the corporate personality is an ingenious tool designed to encourage investment and commercial activity. Now it gets taken to absurd extremes in cases, where, they're treated, it goes beyond matters of mere funding and personal liability. But corporate personhood is not the big evil that I think many make it out to be. And part of this I'm saying is representing both, corporations and people who have sued corporations. It's there as a matter of protection more than anything. Money becoming speech. I'm not sure. Are you referring to a particular decision in that?
Sure, that's great, Adam. The cases that I have in mind are Bellotti against Baird from the 70s, and then there was Citizens United. 2010, which really just opened the floodgates to what people have colloquially called dark money in political campaigns. And
well, Citizens United, that's a terrible decision. And on free speech grounds, it was a law passed by Congress, and John McCain, who was one of the sponsors, said, it was George Bush who signed, when he signed it into law, said, I'm not sure this is constitutional. Let's let the Supreme Court figure it out. And they upheld it, and it imposed these artificial limitations on official campaign donations, which led to the whole idea of dark money. I think it was a decision that its effects are it was unforeseen effects of the decision that are unadvisable. It was a bad policy decision that the court deferred to the legislature on. The good news is Congress can always repeal it if they ever get the motivation to do something about it. But, too many of them, I think, benefit from it for them to want to do anything about it.
Maybe that goes to John Adams' observation that there's something that has an influence on the law. The law is in trouble, and arguably it's the money that's influencing law. And
law is made by people, and it's only as good as the people who make it and interpret it.
Agreed.
Yeah.
Thank you for letting me lead off, man.
Oh, thank you.
And that does get at the point that ultimately, from Plato onward, the whole fight, as they say, it's become more popular today that politics is downstream from culture, but that's always been true. It's not a new discovery. That to the degree that you have a culture that actually is in conformity with truth and dignity, and like John Quincy Adams said that you so eloquently quoted, that the Constitution is made for a religious people, a moral people, and if you don't have that culturally, then a democratic republic it can only exist in name alone. It would never have any essence of truth. So it's a very good point. And the same question for corporations too. I guess you're one of the few people who I've heard come out making the point that that's not actually necessarily a bad thing at all, but feasibly a good thing if you have, I guess you would agree with what I'm about to say, that if you have a culture which actually is moral, then this would not be misused the way we've seen the abuse of it under the past 50 years of globalized insanity.
As we say in law, it's a shield, not a sword, and it shouldn't be used as a sword.
Good point. Very good point. Stephen.
Adam, thanks for a fantastic lecture, very informative. I loved it, and it hit a deep personal interest of mine. As you can see from the chat, I threw a few things up for you. Your lecture kind of juxtaposed my understanding of our own judicial system and court systems and its own failings. And I tend to view the world from historian Christopher Lasch as the culture of narcissism. And a lot of the faults that you point out in the American system, I would argue, are part of what Lasch was talking about, or manifestations of that. And interestingly, there's an obscure part of narcissism theory that identifies that the radical feminist element actually suffers from a form of feminism. And the Canadian court system and political entities are terribly beholden to feminism in Canada. And so I gave some examples and stuff where your lecture where we contradict, I would say, the universal principles of justice in the embodiment of our court systems. Even the last thing we were getting into Plato and talked about, if the courts or the law becomes beholden to special interests or an entity, the society is doomed. Well, we're there. So I just wanted to thank you for what I thought was an excellent lecture. And I put some resources for you in the chat if you're ever interested in looking up to see how not to do it and what a feminist jurisdiction would look like. I mean, our parliament, and just go back to your Washington J comment, our parliament is so beholden to an activist feminist Supreme Court that it now goes out and seeks decisions in advance as to whether or not legislation is constitutional, which says to me our legislatures are too stupid and shouldn't be there because they can't figure that out on their own. But the reality is that the narcissistic Supreme Court has such a sense of entitlement and will do whatever it wants in terms of its activism that Parliament is actually afraid of it, and they're afraid of looking bad and looking like they're immoral actors when their laws are overturned by an activist Supreme Court. So thank you again for a great lecture. I'm going to have to leave shortly for Thanksgiving in Canada, but I really enjoyed it because it gave me a great context to understand a lot of the negative aspects of our own justice system.
Yeah, I have limited knowledge of the Canadian justice system. What I've seen doesn't impress me, to be honest, and I'll definitely take a look at these resources you've given me.
All right, we have time for one more question, and Pascal.
All right. Hello, Adam.
Hello.
Everyone.
Okay, two more questions. Sorry, two more questions.
Great. Thanks, Adam. It was really interesting to hear you on these subjects, and as others have said, to see it as a long sweep of history. And there's a saying, I don't know if it exists in English. In French, it says "Nul ne doit ignorer la loi." No one should ignore the law. And it's basically kind of a saying that goes, you should be responsible. You should know what are your rights and how the system functions, basically. But that's kind of my question. I would like you to elaborate a bit of your view of how the law is being taught nowadays, like a little bit like what Matthew said in the introduction. How do you perceive the transmission of the knowledge of law, justice, all of these principles that, when we look back at Plato, already at the time, the sophists were very good at, I guess, crafting with words. Words craftsmen, but were they really working in the best interest for people and society? Today, we have a lot of our, politicians, our lawyers. I don't know. Can you comment on this?
Yeah, well, the maxim, I think this might be used differently. In equity, there's one of the Latin maxims, ignorantia legis nil excusat, or ignorance of the law is no excuse. And that just means that, you can't say you didn't know it was illegal to be liable for violating the law. Teaching the law, I could give you a whole hour on that, but in law school now is taught completely mistaught. If I had my way, I would go back to how Abraham Lincoln learned to practice law, where you read the law, you studied under a practicing lawyer and learned the trade from practice. Because what you have in law school is pure theory, and often it's agenda driven by your professors, most of whom graduated from prestigious law schools and never practiced law. It's a pure discussion of theory with no real. The best professors I've had were those who actually practiced and had an idea of how what they taught affected actual people, because the law it only exists to affect people. And you're in a situation now, like, I know there have been at least a dozen federal judges who will no longer accept clerks from Yale Law School, which was one of the premier law schools, trained several Supreme Court justices, because the school has been so agenda driven and wacky. I don't know if you've followed any of the news stories coming out of there. I mean, I ask myself, how did these people get in this supposedly selective institution like this? And these are the people who will be slated for government jobs and court appointments. And I'm scared for the future unless there's a realization of that credentials are increasingly meaningless. And, you know, it's those not only with the experience, but those with the proper outlook, the balanced view that Plato had, who should be entrusted, you know, with the care of the law, because otherwise you're just facing collapse. And Plato says that.
Great point. Great point. And I think that sort of gets at the heart of the corruption, which has just struck every branch of human society, from healthcare, medical science, the deployment of law, but also even things like practical engineering, management of transportation, everything increasingly has been taken under the control of managers and people who are trained in management without any real knowledge of the thing that they're supposed to be managing. And we wonder why we're hollowing out and destroying these once viable, powerful components of what supported and improved human civilization for thousands of years. And we're just running it into the hole because, again, there's this whole managerial revolution idea of letting expert technicians control the ship from above. And the people with real knowledge that Plato valued so much in his dialogues, right? He's always putting so much value on the people, the shoemaker, the cabinet maker, the carpenter, the people who actually may not have great theoretical knowledge, but he valued their minds more than the lawyers of his day who were just sophists using speech to win over crowds with no real knowledge of anything practical in the real world. So you really do have to get that balance of both. It's a very vital way to break this. Otherwise, we're in trouble.
Yeah, well, I just have a comment maybe, but
yeah.
What you just said, Matthew, I realized, as Adam has been showing us like more of the American system, and it would be very interesting to have a contrast between the Canadian one and the American one. But as I see it, the Canadian one is much more of a top-down. Like, we don't elect our justices, we don't elect people that are on the courts. So there's like on the American side, there seems to be a top end, but also a bottom up kind of, balance in between. But, I don't know so much, but that's interesting. Yeah.
I would agree with that. And when I go in November to vote, there's going to be in state court, there's going to be judges on the ballot. And some of them I'll vote on a party ticket, and others I'll vote yes, no. I mean, there's an accountability there that you don't get in most other countries.
Mm-hmm. Mm-hmm. Yep, that's important. Peter, let's give you the last follow-up question, then we'll round it out for today's session. Peter, go for it.
Okay. I've got thanks, Matt and Adam. I did have a follow-up to save it for another time, but I'll take it now. Adam, would you comment, for what reason is U.S. law pro-creditor over pro-debtor? I noticed that looking at history, Roman law favored creditors, but Near Eastern societies featured cyclical jubilees, that were usually attached to the sovereign's reign, or sometimes major natural disasters, excuse me. And, for references, I say see Leviticus 25:10 and the Liberty Bell inscription. And then for further reference, I'm bring to mind Jesus' first sermon recorded in the book of Luke on the Jubilee, in contrast to Rabbi Hillel, who favored overlooking the Jubilee. I'll defer to that because it's a really deep subject, and I certainly didn't think about it much in law school either.
No, and it's a peculiarly English thing too. In medieval continental Europe, jubilees were common. You read in Dante the Pope declaring a jubilee year for 1300. Remission of debts. Part of it has to do with the English obsession with the sacredness of the contract. Now that has good aspects. In other words, if you write something down, you're committing to it, and if a court upholds it, you can expect that what you agreed to will actually occur. The bottom side of that is it's very deferential to predatory practices. You know, for example, if you have a jubilee every 7 years, you can't have a 30-year mortgage. You know, your creditors will compress their payment periods, things like that. And there's always the risk that the whole loan could, go up in the air if there's a disaster or something. But is that necessarily a bad thing? I think it's a cultural issue, and it ultimately comes down to, well, it's enshrined in the Constitution too. There's a provision that the Congress cannot, I forget the exact language, but it can't impair
the obligations
under contracts. And that's been fairly loosely interpreted, but it wouldn't allow for anything like a jubilee. I think part of it goes to the experience with that creditors had under the Articles of Confederation. Many of the men who wrote the Constitution were creditors. And again, it has to do with the English cultural obsession with the sacredness of contract. I think it's something that deserves another look, another perspective.
Bankruptcy, would you say, is a recognition of that counter theme? At least there's a kind of a discharge of debts in an orderly fashion.
Yeah, and that's exactly what it does. It's instead of willy-nilly across the board, what bankruptcy does is it allows for an individual debtor to have some relief from his debts. Now that's been limited. The whole controversy around student loan debt is unnecessary and stupid. All you have to do is remove by legislation the exception that bankruptcy doesn't apply to it, and each person with burdensome student loan debt can seek bankruptcy relief like any other burdened debtor. This whole, let's forgive them, or the opposite view of no, you committed to it, you're bound to it. It's extreme opposites that ignore an easy solution.
Yeah. And I'll just share that then Senator Joseph R. Biden was one of the biggest friends of creditors in the United States Senate.
Well, what state did he represent?
Delaware.
Yes. Well, there's definitely more of an opportunity to abuse the law if the people who you are expecting to be abused don't understand what the law is, where it came from, and the principles and predicates upon which justice has been defended and upheld in the past, such that it can be deployed and used again in battle properly. So for that, Adam, you have given us, I think, a lot of weapons, and for people watching this at home, a lot of intellectual weapons to do proper battle in defense. And we need this right now, very, very, very much so, because there is a high degree of illiteracy on some of these very elementary concepts of law, constitutional law, especially here for Canadians, where we've fallen far short. We had the opportunity to have a real constitutional law system hundreds of years ago. We failed to take that challenge. We were given the opportunity again and again and again. We failed every single time. And now we have a basket case system of monarchical law given to us by a hereditary elite upon which we're supposed to expect to defend ourselves. And there's a lot of limitations, obviously, in that. And especially for Americans who have just seen the abuse of this for so long, too, because of their own lack of appreciation of their own history. So you've done a really great service, and I'm looking forward to your second part, Adam. And thank you, everybody, for taking the time this Sunday, and looking forward to next Sunday's lecture, whatever it may be. We'll put out the invitation very, very shortly.
Thank you, Matt.
Okay. Bye, all. Happy Canadian Thanksgiving.
And to you, too.